Welcome to Bill on Bankruptcy. I'm Sarah Kopit, sitting in today for Lee Packia. And as always, we're joined today by Bloomberg News editor-at-large Bill Rochelle. Be sure to check out his daily bankruptcy column on BloombergLaw.com or the Bloomberg Terminal. Our top story this week is Residential Capital, better known as ResCap. It was the bankrupt subsidiary of non-bankrupt Ally Financial, which was bailed out and now about 75% owned by the federal government. ResCap came up with an indescribably complex global settlement to head off a filing of an examiner's report. Bill, this reorganization is pretty much over, but are there any interesting issues that we should be looking out for?
Well, I'll tell you this. The parties, I'm sure, who negotiated that beastly complicated settlement certainly hope it's over. But I tell you, there is a lingering question in this case now about public access to the examiner's report, which, as you said, has been filed under seal. The examiner, a former bankruptcy judge named Arthur Gonzalez, was appointed almost a year ago, July of 2012, and his report, get this, is costing somewhere about $83 million. He was supposed to have filed a report, and of course did, under seal on the 13th of May. Had they not come up with the settlement, the report would have been filed publicly. But now it's under seal, and the bankruptcy judge has ruled, at least so far, that he will not reveal the report publicly until after he rules at a June 26 hearing on whether or not to approve this settlement agreement, which, for all intents and purposes, really wraps up the bankruptcy case. It is, I guess, theoretically possible that creditors in the case could say, oh, hell no, we're not going to go along with this settlement and vote down the plan, but methinks that is not likely. Berkshire Hathaway came riding into bankruptcy court a few days ago with papers asking the judge to unseal the examiner's report. Even though Berkshire is one of the major holders of junior secured debt, Berkshire said, listen here, we simply do not have enough information to know whether this settlement is good, bad, or indifferent, and they are asking bankruptcy Judge Glenn to unseal the report before this argument is held on approving the settlement agreement. For me, I think this is a very important issue concerning public access to court documents, and in particular, an examiner's report costing $83 million, which gets into the nitty-gritty of what had been some pretty nasty allegations about bad transactions between Ally and its subsidiary, ResCap. Well, time will tell how this all works out, but I think if I've ever seen a pristine case about public access to court documents, this is it.
So, Bill, our case of the week this week. You were in court this morning. You heard Lehman Brothers. Tell us about it.
Wow, it was really great theater, but I guess you have to be a bankruptcy nerd to appreciate it. In any event, it's a big case. This is the appeal where the bankruptcy judge awarded the Lehman brokerage trustee $1.5 billion, which would make for a major improvement in the distribution to the brokerage company's unsecured creditors. They went to district court. A district judge named Catherine Forrest reversed, allowed Barclays to keep the money. And I must say, after hearing about an hour's argument in the circuit court today, I'm not about to guess who is going to come up the winner, because, as usual, the judges keep their own feelings very much close to the vest. This much I can tell you, the quality of oral advocacy was spectacular. William McGuire from Hughes Hubbard argued for trustee Jim Giddens, and David Boies from Boies, Schiller, and Flexner argued for Barclays. And I got to tell you, I'm not sure if I've ever heard anybody argue any better, even in the U.S. Supreme Court, which I doubt is a court to which this case will go, because I don't see any big legal issues that will take the case that far up. This was a very important case for claim traders, and believe me, they had that big ceremonial courtroom packed, because there are lots of folks out there trading in these claims. Excuse me. And how this case goes means a lot in terms of what unsecured creditors of the brokerage receive.
So, Bill, most days in your column, you have something called an advance sheet. Do you have an advance sheet for us today, and will you tell us exactly what they are?
Well, yeah, that's a good question. You have to go back before the time of computers to know what advance sheets are. Used to be back in the olden days that the first case reports you got about important new cases came out on really flimsy little pieces of paper. And you had to plow through these things to know what the latest court decisions were. So that's why I call what I write advance sheets, where within a day or two of filing, I try to write up the most important cases that come down in the appellate arena involving bankruptcy. There was a really interesting case from the Ninth Circuit out in San Francisco called Headland involving student loans. In this particular case, the bankruptcy judge found that the former student was in good faith and should be allowed to discharge about 2/3 of what was some $85,000 of student loan debt. The circuit judge looked at the record brand new, as if nothing had happened before, and made his own conclusions and came to the conclusion that indeed this student was not in good faith. He therefore denied the discharge of any of the debt. The circuit court said, no, you can't do that. When the question is one of good faith, the appellate court is bound to follow the conclusions of the lower court unless clearly erroneous. In other words, the lender cannot have a second bite at the apple at the appellate level. This is an important decision for students because it means if you win in the bankruptcy court, it is more difficult for the lender to be able to deny the discharge of your debt if it goes up on appeal.
Student loans, such an important issue for so many young lawyers out there today. Bill, thank you very much for joining us. That's Bloomberg News Editor-at-Large Bill Rochelle. For more on the topics we've discussed today, be sure to check out Bill's daily bankruptcy column, available on BloombergLaw.com and the Bloomberg Terminal. You can also see our updates on Twitter, and for more on our video, check out YouTube. I'm Sarah Kopit. Thanks for watching.